Hello neighbor, I'm Robert Burns, and in speaking with Reverend Freddie Phillips, we wanted to take just a few minutes to bring you the most recent lawsuit that I know everyone is talking about, give you a little overview of what that lawsuit entails, as I know this is a big name lawsuit that you want the details on. It's about a 14-page lawsuit. We're going to give you the ability to click on it and read it in detail. But also I'll very quickly bring you up to speed on the other outstanding lawsuits that are out there. The lawsuit to which I refer was filed on October the 9th in Livingston Parish Court. It involves JAH Enterprises, which is Henderson Auctions, having filed suit against individual Henderson affiliates, namely Lloyd Henderson and the company that he has founded, because it would seem that Lloyd and another gentleman by the name of Henderson have actually gone into competition with the main Henderson Auctions. The facility is apparently 7/10 of a mile down the road on Florida Boulevard or Florida Street, whatever the case. US 190, let's call it that way. And in the lawsuit, the allegation is that clients have become confused. They can't really make out the difference between the two now competitors, in that there is some allegations that the Henderson name obviously has been infringed upon, even though they could have chosen any other name. They have a website. It's henderson-henderson.net, I believe, is the website that can be gone to for the newly formed Henderson competition, Henderson versus Henderson, if you will, within the auction business. And there are allegations that the website is made to look an awful lot like the Henderson Auctions website, and therefore they have effectively infringed upon the trade name and other associated name recognition that has long been associated with Henderson Auctions. The lawsuit goes in to say that there have been deliveries that have been made to the wrong facility, clients have gotten confused, things of this nature. And then there is an added paragraph that pertains only to Lloyd Henderson himself individually. I believe that's paragraph 36, but don't hold me to that. You're welcome to see the entire lawsuit. But if my memory serves me, it is paragraph 36, in which it is alleged that Lloyd Henderson, apparently there was a equipment package that was going to be available to be purchased and then to have commissions earned upon it, or to subsequently resell the package of equipment. It is alleged in the lawsuit that Lloyd Henderson and Marvin Henderson discussed these prospects in October or November of 2013, and then a few weeks later Marvin decided to pursue it, only to find out that the package had actually been sold. And then a few weeks later the package arrives at Henderson Auctions, and the long and short of it is that Mr. Marvin Henderson alleges that Lloyd Henderson went behind his back, utilized some unidentified client's money to finance the purchase of this equipment, and that he engaged in self-dealing, from which he profited, and all left Marvin holding the bag, so to speak. And as a consequence, apparently all employment-related association between Lloyd and Marvin was severed in January of 2014, as the lawsuit alleges, and they are looking for injunctive relief, basically to bring a halt to this attempt to duplicate Henderson's Auctions, to form another Henderson Auctions, if you will. Not saying they can't operate, but that they're not going to be able to make it so closely identifying with the long and established Henderson Auctions. So that is the nature of that lawsuit. Of course, they're seeking any damages that they can as well, they being Jeff Henderson, Marvin Henderson, JAH Enterprises. The actual entity suing is JAH Enterprises, which is Jeff Henderson's firm, Jeff being on the LALB. But Marvin has long been known to pretty much run Henderson Auctions. So that's the update on what I know is the lawsuit everybody's been waiting to hear about. As I said, today is October the 13th. It's Monday, October the 13th. That lawsuit was filed on Thursday, October the 9th. So we are bringing you as timely as we can this type of information, I think you'd have to agree is fairly timely. Now, while I was there, and I was there today at the Livingston Parish Courthouse, I did go ahead and pull the lawsuit that we referenced to you previously, and you can see that video just beneath this video on the page, entailing Marvin Henderson having sued a gentleman named Blake Everett. That was the casino operation. You can go watch the totality of that video for the allegations that are in that lawsuit. The only thing I'm going to say here is that they were unable to get Mr. Everett served in the state of Mississippi through the U.S. Post Office. I don't think that's any big surprise. And then the revelation was made that even though they had procured Mississippi counsel to represent them, they being Blake and Sam Everett, that the counsel has refused to accept service. It's going to have to be served upon the principals. And so there was a motion filed before the judge to hire a private process server who facilitates getting folks served even when they don't want to be served in the states of Texas, Louisiana, and Mississippi. The judge signed that order. I believe the date of the signing of the order was August 25th. We'll have that link. You can click on it. It's really not important the date it was signed, but bottom line is there's a little bit of difficulty getting these fine folks served, and so they've had to jump through a few extra hoops. So that's about the update that I can give you on that particular lawsuit. With regard to the sales tax lawsuit, with regard to the Department of Revenue, there was basically nothing in that file added other than a letter from attorneys representing the Livingston Parish School Board and attorneys from Mr. Henderson saying that everything had been successfully resolved. There was no specificity as to what kind of terms were arranged on that, which I'm only hypothesizing on that the state would then remit, because the Livingston Parish School Board was never a party to the suit, but obviously the state must have been willing to do the heavy lifting for them and then remit their share of the uncollected sales taxes. It'll be more revealing if we see the dismissal from the state. We'll just wait and see if there's specificity as to what the terms of that settlement that was reached. You may recall the trial was scheduled for September 5th. I'm sorry, September 15th, the week of September 15th. We last brought you a video right on the eve of that trial, and we gave you a subsequent updated email that said that the trial had been settled immediately prior to the trial commencing. So that takes care of all what I'm going to call the Henderson-related lawsuits, the most noteworthy of which, of course, was the very first one that I discussed with you. Let me briefly bring you up to speed on the other lawsuits that are out there. Everyone is familiar with the Betty Story lawsuit. That was the one, well, first of all, let me just say this. There are two Betty Story lawsuits. That is the lawsuits entailing the Marlowe Schmidt auction. Many of you may remember September 10th, 2013. I know a number of you went and watched the hearing after you received word that the LALB had been sued by Miss Story, and we want to commend you for having done that. Miss Story's small claim suit will take place on October the 29th in City Court in DeRidder, and so that will give you the update on it. She is alleging, obviously, that Mr. Schmidt failed to reduce a number of the items that she wanted in that auction to specific reserve prices, and instead she was required to bid on those items, and the commissions for those the higher end items that she was unwilling to sell at lower prices more than offset the proceeds from the other items, as well as the fact that he was charging her a 40% commission and a 10% buyer's premium. So you can do the math as to how quickly that would add up. I did look at a document in the file. I don't want to be held to this figure, but I think it may have been $3,800 is what she was charged to buy her own stuff back. You may also recall that based on certain representations that she said was made to her, she went ahead and moved into the Canterbury House, which is a assisted living facility in Alexandria. She stayed there 3 nights, only to have to leave the facility once she got wind of the abysmal results of her auction, and the Canterbury House assessed her $1,500 for that 3-night stay, of which she would certainly not have incurred had it not been for some of these representations about what she could expect to realize from the auction. At least those are the core allegations in Ms. Story's lawsuit. As many of you are aware, Ms. Story also sued the board, the LALB, and that being because she feels that there were pretty egregious auction statute violations here, and yet the board found him not guilty. They did give him a strong tongue lashing. That's not money you can put in the bank, okay? A tongue lashing is not something that Betty Story can go and put in the bank. Ms. Jacobs-Levy certainly indicated to Mr. Smith that she felt that the $1,300 that Mr. Smith had offered to settle the matter was certainly inadequate, and he needed to come up with more money. But there again, there were no findings of guilt on the part of Mr. Smith. Consequently, Ms. Story's ability to file a claim against Mr. Smith's auction bond was effectively blocked by the LALB's action, and that is the nature of her lawsuit against the LALB, is that she is seeking directly from the LALB the $10,000 that she could have recovered through Mr. Smith's bond had the LALB found him guilty, but since they found him not guilty, they effectively blocked her ability to collect on that bond. So I'll bring you up to speed on the Betty Story lawsuit. The Judy Fasola lawsuit, that was a lawsuit she filed in Baton Rouge City Court entailing Mac Bueller, who was the sponsor for Ken Bueller's license when Ken was under restrictions about what he could and could not do. And that was the source of her lawsuit, was saying that Mac did not adhere to his obligation to be the one who was negotiating with clients. I won't go into other details of the auction because they largely parallel Betty Story's lawsuit, that reserve prices were not put in as they were. Now, in sharp contrast, the board did find Mac Bueller guilty. All right, she filed the small claim suit. Unfortunately, on August the 24th, when he came up for trial, Ms. Fasola was 10 minutes late to court. All right, judge dismissed the lawsuit. Not a good idea to not be on there on time when you have a lawsuit that you filed, especially when you've waited this long. That auction was 2 years ago. Here was your chance to get some remedy. She was late. I understand she's working on trying to remedy that. The lawsuit was dismissed without prejudice, which means she has the right to bring it back, and I believe she may have imminent plans to do so. So I'll bring you up to speed on the Betty Story lawsuit. Let me just give you a quick rundown on the lawsuits Reverend Phillips and I have with regard to the LALB. We will be in court tomorrow morning arguing before Judge Caldwell. By the time you watch this, we probably will have already conducted those arguments. That entails a lawsuit of what I call the kitchen sink. Mr. Bankston, counsel for LALB, is attempting to get that lawsuit thrown out by way of a peremptory exception of no cause of action. It's a pretty common procedure that most attorneys may do if they don't feel you've adequately stated a cause of action in your lawsuit. We believe we have. That lawsuit entails Chris Lemoyne having blocked the video coverage of the meeting, and we contend that by the repeatedly harassing conditions that the board placed us under to videotape these meetings, and we have that lawsuit replete with examples of that, we assert that they took on the risk by having us sit by such hostile audience members, and therefore they are liable for 16 months. We could do just like I'm doing now. Set up the tripod, although it's a unipod, minimally invasive, okay? And then there wouldn't have been this ability for Mr. Lemoyne to stick up that white sheet of paper and block your ability to see the video, okay? But oh no, the board couldn't have that, so they implemented these so-called rules. Even though everything was going fine for 16 months. One of those rules was couldn't have the electrical outlet. You may recall the March 2012 LALB meeting where Ms. Steinkamp's New Orleans auction gallery was going to be discussed. Well, Ms. Steinkamp wasn't going to have any of that, and she had Deputy Landry unplug the video. All right, we've got the first 2.5 minutes all the way to the point where the gentleman did unplug it, okay? All that's all cited in the lawsuit, obviously, but they didn't like all this, okay? And we have been subjected to repeated harassment, so if they wanted to take this on, they got it. Okay, they've been sued, and we are alleging that they are liable to us for having blocked our ability to fully videotape that May meeting. And make no mistake about it, we are not going to stand by and permit this kind of obstructionist activity to take place without it being vigorously defended in court. So, if you happen to be an LALB member, or if Governor Jindal may be recruiting you to serve on this board, we would welcome any auctioneer to replace the ones, well, we have one consumer member out and one auctioneer member out. Hal McMillan is out as the auctioneer. Greg Bordelon's been out for over a year now as the consumer member. But if you are being recruited to serve as an LALB member, we would welcome you, provided you're going to adhere to the conditions of Title 42 in the Open Meetings Law. I'm here to tell you right now, if you get on this board and you do similarly to what this other board has been doing, I will have the lawsuit ready before you can get home from your drive, okay? We're not fooling around with this. I think we've demonstrated that. And if you think we are, when you get on that board, just continue the same pattern you've seen some of these board members with, and you'll have the lawsuit. You have my word on it, okay? Now, as I said, if you're going to be a member who's going to get on this board and adhere to the Open Meetings Law and provide transparency and not subject to this kind of hostile conditions that we have, and let me just say, I will commend Hal McMillan. When he resigned, and we've got the video of it, I'm sure you've seen it, he wanted it into the record that we had support. So it was a little bit of a bittersweet feeling to see him resign. But whoever takes his place, if you want to join in with the folk and the way they've been running things, let's go forward. I got plenty more stationery, okay, plenty more, all right? And rest assured, you will be sued if you follow the same actions of these other board members. Now, that entails that lawsuit. There is also the lawsuit that I filed individually. Reverend Phillips was not part of this one. That entailed the whole so-called hearing that they conducted on me. That case was tried on April the 9th. It is presently on appeal with the First Circuit Court of Appeals. The appellate brief, that would be my brief, I am the appellant in that particular case, has already been filed. The appellee brief, that would be the LALB, Mr. Bankson is nearing the 30-day window that he has to file the appellee brief. It will probably be on the order of 6 months before the oral arguments will take place with the First Circuit Court of Appeals. So probably sometime around March or April of 2015, we should have the ruling from the First Circuit Court of Appeals as to whether they want to uphold Judge Fields' ruling, which I certainly don't believe they're going to, or wouldn't have filed the appeal, or whether they want to overturn it, in which case it's going to become quite costly for the LALB members, because the statute clearly says that I am entitled to recover all of my court costs as well as my attorney's fees. And while I have been so generous in representing pro se at the trial court level, I'm going to tell you I don't have the expertise to argue before the First Circuit Court of Appeals. So I did retain an attorney, and I will be more than happy to collect for the fees from that attorney upon a successful overturning of that award, should that transpire. So that brings you up to speed on that lawsuit. I believe I've covered the last one. How can I forget the infamous Eyes Here lawsuit? Okay, what's going on that one? Both sides have filed a motion for summary judgment. We had our hearing before Judge Hernandez on August the 4th or 5th, I believe it was the 4th, entailing our motion that we do not believe a trial is even necessary. We believe we have substantiated that this board did not let us speak. I wanted to speak on the illegality of per diem payments, which, by the way, they subsequently had to refund. The payments were illegal. Mr. Bankson had sent an email to say I could speak on the matter, and then Ms. Steinkamp, Mr. Bordelon, and Mr. Sims said, no, you're not going to speak. Now, Ms. Jacobs was on record, she's clearly on the video, as saying I have no objection to them speaking. Therefore, she was not named in the lawsuit. Smart move, Ms. Jacobs. We also have Mr. McMillan, who voted against the entire public comment policy. As I said, and as he said, we did have support. And as a result of his steadfast stand that he did not support suppression of public comment, he too is not named in that lawsuit. But the other three board members, Mr. Bordelon, who is, of course, now no longer a board member, but he's still liable for the actions he had while he was on the board. So bear that in mind too. Just getting off the board is not going to be suffice to absolve you of your prior liabilities for the time you were on the board. Mr. Bordelon, Mr. Sims, and Ms. Steinkamp do find themselves defendants in that lawsuit. Judge Hernandez took both matters under advisement, and we are awaiting his ruling in that regard. Probably will be within the next 30 days or so. So that brings you up to speed as best I can relay to you all of the lawsuits that are outstanding, including this most recent one filed on October the 9th with regard to some tension and friction that have taken place within the Henderson auction camp. You'll recall that on the Everett lawsuit, I said you've got to really be careful and really have a high level of trust when you are auctioning merchandise in which you have an interest. And I think this lawsuit proves it even more. Okay, we've got a link that you can click on to see the lawsuit, because even when it's within your own family or at least related parties, if you will, that are in the same entity and presumably rowing on the same boat, you can still have problems. And this lawsuit demonstrates it. So with that, I believe I've covered about everything. Reverend Phillips wanted us to bring this update to you. I hope you found it beneficial. The next LALB meeting is not for about a month. It should be an interesting board meeting. I know there's some items on the agenda that are going to be interesting. I'll put it that way, and we look forward to bringing you that meeting. It will be on November the 5th, so we are about 30 days away. In the meantime, I hope that you've been able to find everything quite interesting. Hope the election may go your way. The 5th. I think the election's on the 4th, so I guess the board meeting will be the day after the election. I think the election's on the 4th, but the 5th would then be a Wednesday. Whatever the case, if you're pulling for a certain candidate, I hope things go your way, and we'll look forward to bringing you the LALB highlights from November 4th shortly thereafter. Once again, this is LAPA Vice President Robert Burns, and it has been such a delight to come to you and bring you this update. Hope you found it informative, and we look forward to visiting with you again in about 30 days. Thank you so much.